You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And, I was just thinking this morning, David, it's like when we first started this podcast last year, I think on October, November, whenever it was, and we decided, hey, we're going to do this every week. Every Friday, we're going to release a new episode. And I thought to myself, man, that's a lot of pressure. I'm not sure that we're going to have something every week to talk about on a show. And as I sit here this morning, there are so many issues from what's happening here in Tennessee locally with COVID and schools reopening and mask mandates and governor's executive authority. And we've had about, I don't know, no less than maybe 20 SCOTUS decisions in the last 2 weeks that are impacting everything from religious liberty to, it's just incredible. I'm like, now we need to start doing this daily because we just can't keep up anymore. So we'll get to SCOTUS in a minute, but I will tell you this: I never, living in Williamson County, Tennessee, which I guess I sort of always thought as one of the bastions of conservatism. I mean, when you think about Tennessee, and then you drive around Williamson County, you see all the beautiful farms and just the land and the people who just love God and love country and just good old Tennessee. I never thought that we'd be one of the counties, one of the minorities in the entire country that are issuing these crazy we have a mask mandate, by the way, David, in Williamson County. I don't know if you know the penalty, but I spoke to the sheriff myself. They have not ruled out an arrest. And in Williamson County, it comes with a fine of up to $2,500 and a year in prison for not wearing a mask.
Right.
What the heck?
Public. Yeah, and I didn't realize this, but you mentioned before the show that Davidson County, which is, for those who don't know, the adjoining county where Nashville is, they've got a mask requirement, but it's only, I think you said, a Class C misdemeanor.
Class C with a fine of up to $50 and 30 days in jail. Right. So you cross a county line and it's a whole different world.
Yeah. And you know what's flabbergasting to me is that anybody who's a lawyer, who's advising the governor, now the governor's an engineer by training, so he's got to rely on what lawyers can tell him, who would advise the governor that he has the authority as an executive branch official. Remember, we have a constitutional restriction called the separation of powers, not a statutory one. The governor cannot make state law. The governor's executive order that he issued earlier this week or at the end of last week, I don't remember what it was. Our grandchildren were here, so I lost track of time. But the governor only urges people, strongly urges them. Great, fine, good. Strongly urge me to wear them. That's great. But then he delegated authority to 89 of the counties that don't have their own health departments and are covered by a different law. The authority, not for their legislative body, but for another executive branch employee to decide whether there will be a requirement or not, and then subject it to the kind of state criminal sanction that apparently the mayor chooses. So the mayor of Williamson County says it's going to be a Class A misdemeanor. The mayor of Davidson County says it's a Class C misdemeanor. So whoever thought you could advise the governor that you can delegate lawmaking authority, state lawmaking authority, essentially, okay, because these are state criminal sanctions, to another executive branch employee and not have, if nothing else, equal protection problems.
Right.
Because the same conduct is subject to different state criminal penalties in different counties.
Yeah, there's no consistency in how you apply that law from county to county.
So you got an immediate equal protection problem. I mean, if I had the time, I would try to gather as many people in Williamson County as possible, go to a Williamson County park, call a press conference, and we'd all take off our masks. And when they come after us for our Class A misdemeanor, file a civil rights cause of action against the mayor, county mayor of Williamson County, and the sheriff, because I am subject to a criminal sanction at the state level that's different from county to county.
Yep.
That arguably the governor had no authority to even allow them to require a mask, let alone to choose the kind of criminal penalty. This is absurd.
Yeah.
This is the loss of constitutional government. And in my commentary today, I'm not pointing the finger at the governor so much. I mean, they passed a law. I think he's probably misread and misinterpreted the law. But by golly, I expect my state senator and I expect my state representative to immediately go to the governor and say, you cannot do this.
And
it's just so unconstitutional.
And to my knowledge, we don't have a
and I'm calling a special session
doing this,
and,
right?
And my state senator happens to be the majority leader of the state senate. Yeah. That's right. And if these people in our legislature cannot see that we no longer have representative government, they don't deserve the title of being our representatives.
I'm with you on that.
They can't take an oath to uphold the Constitution when they cannot see the constitutional problems here. And if their deference is to the governor because he's the governor and because he's a Republican, rather than to those they represent to say, we will uphold the Constitution because we took an oath for it.
It's a great point.
Then we need to start writing in Mickey Mouse if they're unopposed. See if Mickey Mouse can't get 3,000 or 4,000 votes in our state legislative races.
It's a great point.
This is just wrong.
Yeah.
And I'm not the only one calling it out. American Policy Roundtable, brilliant guy, know him. Now located here in Nashville. He used to be in Cincinnati, where I used to live, but he's calling it out. This is just wrong. And if the governor thinks it's such a big deal, he should require the mask. But he didn't. And I appreciate that he's trying to let local governments govern. Okay, that's a great principle. But you can't then allow state criminal sanctions to vary from county to county based upon a decision, particularly by an executive branch type of employee at the local government level.
Right.
I mean, that's just fundamentally wrong. And I'm not saying we shouldn't wear a mask. I'm not saying that masks are a bad idea. I'm not saying you're a communist if you think we should wear a mask or you want to wear a mask. I'm talking here about constitutional precepts and principles that need to be adhered to. And the best way to road to tyranny is to use a crisis to abolish the forms that protect our liberty. And one of the things they ought to do, and they talked about it and didn't do it, was at some point saying once an emergency is declared, a governor under the law can keep renewing it every 60 days ad infinitum.
Yeah. That's the other issue.
They'd have to come back into session and change it. And why they didn't change it then, I don't know.
Right away, while they were in session.
Yeah, it was supposed to be a COVID-based session. So they should have looked at the law, and they didn't. Now, they're now seeing the delegation of authority to another legislative branch, executive branch person at the local government level to vary state criminal penalties from county to county. And if they can't see that that's wrong, they don't deserve to be in office. I just put it that bluntly. They don't deserve to be in office. They don't understand what they're doing. They don't understand the Constitution. They can't uphold their oath to uphold it because they don't understand it. This is vitally important for constitutional government. And I'm going to look to see what happens. And I don't know, maybe Gary, you and I'll get 100 friends or so, and we'll just all go down to Williamson County Park.
I'll be down there.
Yeah, I can represent us. You know, we have a constitutional government defense fund.
That's right.
And
that's right.
It may be fun to go into federal district court and file a 1983 cause of action. We could recover our attorney's fees, which would be a change for us, wouldn't it? Instead of spending money, we get the government to pay us money.
That'd be great.
Okay.
The tables. Okay. So
well, let's get on to serious.
So obviously we're frustrated about that, and we'll be talking more about that later. But we need to address so many things that have happened in the Supreme Court. But one recently that happened this week, I suppose. Well, two cases having to do with religious liberty. One with the Little Sisters, and I believe as to whether or not they needed to pay for contraception for their providing health care to the employees. But then this other one regarding a church, a school, Our Lady of Guadalupe, I believe in Hermosa Beach in California, on a ministerial exception. And the verdict went our way, thankfully. All of the religious folk are cheering victory, but I know that you have a few words of caution on how this victory could be very short-lived. So let you dig into a little bit of that.
Yeah, our tendency is to want to claim victory whenever we can, particularly when we're not-for-profit organizations. Our donors want to know, hey, are you having success? Are you winning? Particularly, when you're involved in the actual matter. And of course, we weren't involved in either of those lawsuits, so we didn't, quote, win or lose. But the victory for the Little Sisters of the Poor, people need to put it into context. It's not that they didn't win a favorable judgment. It wasn't that, because they did. The court said President Trump created an exception consistent with the Religious Freedom Restoration Act under the broad authorities given by Congress to the bureaucratic state to effectively create laws, and there's nothing wrong with it. So the exemption for the Little Sisters stands. Yay, that's great. I'm really happy. But people need to appreciate two things about it. You immediately saw that Joe Biden said, if I'm elected president, I'll reverse this. Right. Now, you may be thinking, why is it when conservatives lose, like on marriage or abortion, we don't immediately say, well, we're going to reverse this. We just go, oh boy, we lost. What can we do? We'll just lay down and do whatever they say. Liberals don't do that. And the reason we need to appreciate is that all the court said was the president had the authority to do what he did. Biden would have the authority to go back to what Obama had, which started the lawsuit in the first place. So depending on who the next president is, we may find that their victory lasts till he's sworn in January. And then that's one of the first things he begins to change. Well, how big is it a victory if it depends upon the election of one person to office,
right,
and regulations that are adopted?
And everything
that's not a huge victory. And the other thing that has to be appreciated is that the Religious Freedom Restoration Act is still in place. Now, here's the problem Biden might face. The court might say to Biden, you have to, because of the Religious Freedom Protection Act, create some kind of exemption for religious organizations. So in that sense, there's a win. Even Biden might find he's more limited than he wants to brag that he can be, because he still has to deal with the Religious Freedom Protection Act. And here's the point about that. That is a statute. It is not the Constitution. And consequently, that statute can be repealed. Now, whether they can ever muster the votes to repeal it, whether they can get enough Republican in name-only senators to modify the Religious Freedom Protection Act or repeal it, I don't know. But in essence, your religious freedom depends on the continued existence of the Religious Freedom Protection Act. And that's just a statute. And so this is not as if we won a constitutional liberty claim.
Well, and so on that, I got kind of have a question on that note, because we've had some conversations about these and some frustrations about continuing to decry religious liberty on every issue, and at the end of the day is continuing to fight for quote unquote religious liberty, especially in this culture and with the judicial supremacy that we face every day, is that really protection enough? Because I look at this situation, for example. Let's stick to the case at hand in this Guadalupe. The school fired a teacher, and the argument, that it was won on religious grounds, but the lawsuit really was based on age discrimination, not any sort of religious discrimination. So the school, apparently by the court, they nullified the plaintiff's objection on age discrimination, and the court gave them a win for religious liberty. That just seems like not a very solid foundation to build anything on. And so my question to you is, I've always thought, wouldn't the more right thing, or the thing that really would protect our rights, is for us to be able to just abide by our conscience in general? That's the issue with all of even things like affirmative action and just all these discrimination laws that create a whole host of issues for private entities to simply do business and act on their own conscience in the way they see fit, versus us trying to get a religious liberty win every time something like this comes across the desk of the Supreme Court.
Yeah, I mean, I think that's a great point. That one of the things that's been forgotten is that these civil rights laws are laws. They're statutes. They're not constitutional.
It's not a constitutional
mandates.
Yeah.
That's right. So it is the government. The Constitutional Bill of Rights is to protect private individuals, to protect individuals from government intrusion. Okay? But they were not intended to protect private people from private people, except for criminal laws. I can't beat you up and assault you and libel you and slander you and, those kind of things that were normal common law kinds of crimes and torts. But the idea was that we leave the private sector to regulate the private sector. Now that does mean there are going to be private sector actors who do bad and wrong things.
Certainly.
And so we then say, well, that's just bad and wrong, and we ought to stop that. And the next thing you know, you've got the government stepping in, and then somebody tries to use that law to expand it further and further and further, rather than saying, should we re-examine what we do in the private sector? One of the things that I hadn't thought about this, but one of the things we're seeing with all this racial discrimination is we can pass lots of laws. We can have a whole lot more, but they don't make people good. They don't make people good, and that's of course exactly what the Bible said. Law doesn't make you good. I gave you law. I gave you good law. Don't murder, and anything that's in the context of murder. But you still hate people in your heart, and it's murderous.
Yeah.
It didn't make you good. You don't have the power to be good. So we can just law ourselves to death, and we're not going to be better. And so we really need a reformation of the heart. And nobody wants to talk about that. And that's unfortunate. But one of the things that we see here, so the problem with not addressing these questions at a more fundamental level, which is what you're really talking about here,
sure,
is that other people who don't like the way they got treated in the private sector then want to be included among the list of people who get extra protections. And that's where you have to have some principle by which you decide what the law will affirm as good and what the law will affirm as wrong or bad. On what basis people can make discriminating decisions in the private sector. And these people that say, I'm against all discrimination, and I hear it all the time. We're against discrimination. It's kind of like, well, did you hire the first person who applied for a job? Well, no, I took in lots of applicants.
Yeah.
Well, you discriminated.
On some basis, you discriminated.
You chose this person over another person. Yeah. You do it all the time. We do it all the time. And so what really is happening, particularly as we look at the sexual liberation agenda, is that when you hear this, religion is used as a license to discriminate, a license to get around the civil rights laws. What in essence they're doing is they're discriminating against religion per se. Religion is bad. And
Sure.
so no religious exception should be allowed. Well, that's essentially their religious view, which begins with a belief that man is sort of God, man makes his own law, God is irrelevant to human law, moral law is irrelevant to human law. So see, that God does not allow us to avoid him. We can deny him, we can suppress truth, and that's what they want to do, is they want to say all law is man-made law. And any law or any religious exemption, whether it's Hindu, Islamic, Christian, Buddhist, whatever it is, it's out of bounds because it violates our religious tenets. That's religious discrimination. That's viewpoint discrimination. And so we just need to man up here, or woman up, or whatever it is, and admit we're all in the business of discriminating.
Yeah.
The question is, on what basis should discriminations be made?
Yeah.
And that's where our Supreme Court got way off base with its Title VII decision a few weeks ago. But the goal here, we need to appreciate, the goal here is to exclude all religion from the public square. That's behind the statement, religion is a license to discriminate. You can't use your religion as a basis to discriminate.
Absolutely.
That's the goal.
And that's totally what's behind Biden's statement. When I get in office, I'm going to take care of this thing. I mean, this is what these guys want. They just want religion out of the way completely. And we, for some reason, maybe we see it and we just don't care, but it just seems like we keep fighting old battles, and we better start fighting the right ones.
That's right. Now, I will say that there was one positive decision, in a sense, this week, and it was the Our Lady of Guadalupe, I think it was, versus Morsi Beret.
Yeah,
and it was
that's one we're talking about with the teacher that sued over age discrimination.
So the Little Sisters of the Poor was a win as such. The nice thing about the Our Lady of Guadalupe is the court said, we're not going to get into deciding what your religious tenets are or are not, or who in your religious view constitutes a minister.
A minister, yeah.
And titles aren't necessarily determinative, because a lot of people don't use titles, different religious beliefs, even within the Christian community. I think the Church of Christ refers to their person maybe as an elder or a preacher or something. They don't tend to use the word reverend or minister. And so that was positive, that the Supreme Court said, notwithstanding, or even if there were no Religious Freedom Protection Act, you're wanting us to get ourselves entangled in deciding what a religion considers to be a ministerial position. And we're not going there. That's excessive entanglement. I love that Thomas wrote a concurring opinion that says, we got some people so worried about religious entanglement, with government being entangled in religion, they don't even want to let a Christian school apply for, rubberized tires to go on the playground. Yet those same liberals want to get into deciding that you can't decide for yourself what ministerial functions a teacher carries out. And I thought it was kind of good.
Based on what you're
slapped him on the face.
Based on what you're saying right there, I have a comment from Alito in the opinion. Speaking of that particular issue, he said they were members, quote, they were members of the school staff who were entrusted most directly with the responsibility of educating their students in the faith. They were also expected to guide their students by word and deed toward the goal of living their lives in accordance with the faith. And then he goes on to say, they play a vital part in carrying out the mission of the church. And what he was saying is, regardless of title, regardless of what these teachers do, I think we mentioned earlier, well, what if it was a janitor? What if it was someone else? Alito was saying it's not our job to discern discern on their what's their position. The bottom line is they're at the school, they're part of the church, and we expect that they are, whoever they are, they're guiding these students in matters of faith. And as far as the court, that's the viewpoint we have to take here. We can't get into the weeds on, well, what does this person do and what does this person do?
One of the questions became what they call co-religionists, and one of the teachers that was fired said, well, I'm not a practicing Catholic, and yet they hired me, so therefore they really don't care. And he said, we don't want to get into a court to deciding what it means to be a true Catholic. You were hired to do a job, you do the job, you took the kids to mass, you did various things, so on and so forth. We're not going there. Because I think what would next happen is that, a Baptist church has a school and you hire a Presbyterian. We don't want to get into, you believe in covenant baptism and sovereign grace, and so you're not really a quote Christian teacher for the purpose of the Baptist school.
This person wasn't Baptist enough to come under the ministerial exception.
That's
wow.
Right, that's right. Now, I think there will still be an open question. I was on a conference call the other day. What happens with the janitor, for example, who maybe comes in mostly after school and picks up trash or whatever? Would this decision, if that janitor all of a sudden decided he was a woman, if he was a man, or vice versa, or whatever, could you let him go? And so the advice was, if you're a Christian school or a Christian ministry, you better spell out exactly how you understand what it means to carry out ministerial functions. And so, for example, with the janitor, I knew the janitors at my elementary school. Now, I saw them off and on in the day. Today, 60 years later, I can't tell you if they were there in the morning and then gone most of the day and came back in the afternoon, but I knew who they were. And I knew who the janitors were at my church when I was growing up. And so a Christian school could very well say, look, if that janitor sees some little child crying, I want that janitor to be able to minister to that student. I want him to have some perspective. So no, he doesn't have to go to seminary, and no, He doesn't have to understand all the difference between, dispensational theology or whatever else it might be. But people need to be able to respect the janitor and say, even my janitors are Christians, not just my teachers. There is no compartmentalization in our school. This is a Christian school. We're a part of a body that is joined together in Christ. And that's who we are. We're not just a bunch of isolated people who make different decisions. And so anyway, that was really somewhat what I would call, a victory. The court saying we're going to stay out of this.
Yeah.
And Clarence Thomas noted rightly that we need to clean up our establishment jurisdiction cases because we have some inherent conflicts here. And I've kind of come to the position, Gary, over time, that you're not going to clean these situations up like Clarence Thomas was talking about unless you attack them,
Yep.
Unless you go at them with a frontal challenge and say, you got to clear this up. You're going to have to speak to this issue. Half measures and roundabout ways of doing things just give excuse makers an excuse.
Maybe we should take the advice. What is it? Ilhan Omar out of senator or representative out of Minnesota said, it's time for us to completely dismantle the system, burn the system down.
Yeah.
I think to some degree on these issues, it's time for us to see things what they are, and like you say, confront them head on and stop nibbling around the edges and getting the little breadcrumbs, that we can get. We've talked about that, so many times on the abortion issue. We continue to argue as if Roe v. Wade and Planned Parenthood versus Casey is good law. We accept them at face value and just try to get what we can around it instead of just going
saying
head
no,
on and
no.
saying, no, we don't accept this. This is unconstitutional. It's bad law. And so I think, we need to do the same thing here. It is time that we got to start fighting for a few things, David. Like, I know Christians don't like to fight. I get it. We want to love everybody, but it's time to fight a little bit. We got to fight a little bit.
Yeah, well, we just have to stand up for what we believe and not apologize for it.
Yeah.
And if we lose, well, we lose. There were a lot of early Christians who lost. We called them martyrs.
Back in the Old Testament, we did have those times where we had to go in and take the land. I mean, those things happen.
So, for instance, on this conference call I was on yesterday with the National Legal Organization, they did discuss the abortion case that came out a couple of weeks ago out of Louisiana, the June medical case.
June medical, yeah.
And so they were talking about, I think the good thing about Robert's opinion, even though he stuck with Hellerstedt, was that he did say that the courts are not to get into this benefits, burdens, and this will drive the cost up to here, and this will do this, and and all that when it comes to maternal health, and that it's just an undue burden standard for deciding if something is related, an undue burden to is a What they said is the question now is just simply whether a provision in the law for the purposes of maternal health is an undue burden. And I wanted to say, I hate to say it, but the word undue burden is a subjective word. It's going to still be weighing, isn't it?
Yeah, absolutely.
What's due to one person may be undue to another. It's a subjective determination. So, okay, we're not going to call it balancing because that's obviously subjective. We're going to call it undue burden and hope everybody's stupid enough to think there's nothing subjective about that.
So
that's subjective. And here's the problem going on. All they talked about was maternal health, maternal health, maternal health. And finally, I popped on I said, well, what can we do to say that the unborn are persons under the Constitution?
What about their health?
Yeah, what about their health? And you know what the answer was? Well, I think we may be in good shape for fetal pain bills because fetal pain doesn't kick in until 22 weeks, which is equal to viability.
You mean the bill that just didn't pass in Congress?
Yeah. But the point is, you're saying, okay, we've now painted the picture for people that we don't want babies to feel fetal pain. But their concession was, that's at 22 weeks, which is basically viability anyway.
It's where we are now.
So you didn't change anything.
No.
You didn't save more babies by fetal pain bills.
It's right where we are.
You made yourself feel better, but you didn't change anything. Then they said, I think we can also, maybe win on the sex selection and ethnic abortions. And so we need to just keep chipping away. And, in time, we think the court will reverse. And I want to say, and so we're at 47 years chipping away. So the strategy is to keep doing for what, 10 years, 15, 30, another 47 years? How long do we keep chipping away before we punch you in the face and say this is wrong? and I thought, I called a friend of mine after it was over, a really, really sharp lawyer. And I said, am I wrong? But how do you enforce a law that prohibits abortions on the basis of sex or ethnic, ethnicity? He said, it's impossible. What doctor is going to put in the records after talking over with the woman the fact that she didn't want a boy, we decided to have an abortion? You think they're going to put that in the medical record so you can prosecute them?
It's ridiculous.
I mean, we need to wake up as pro-life Christians
we're doing
and say,
nothing.
This makes us feel really, really good.
Nothing.
You can't kill a baby because it's a girl, but I can't really prosecute you because you're going to never admit that's why you did it. You'll say it was economic stress. You'll say it was emotional stress. You'll say it was whatever you got to say it is to avoid it.
To get what you want.
To get what you want. So pro-life community, when you see people saying, oh, we're going to prohibit this, think about whether it's enforceable. Think about, oh, good, we got rid of this balancing test for the undue burden test. That's still a subjective test.
Yeah. Well,
That's kind of like saying we went from the bad art test to the good art test. Oh, great. Now we're only going to put good art in the museum. Who's going to decide what's good art, you know?
In the closing few moments here, I have one more thing for you. Maybe you know, and this just came to mind, so I'm not sure if I'm 100% right on the case or not, but I read an article, and of course, you know, with these recent Supreme Court decisions, the story is that Justice Roberts has just become this precedent monster. Everything's about precedent. I can't overturn precedent. I can't precedent. Well, what about, is it constitutional or not? Is that maybe why you're on the bench to discern what? And so someone made a great point, and I think here's what I'm not sure about. I know it was one of the cases that they recently heard, and I think it was the June Medical referring to the Hellerstedt case, but it could have been something else. Right. But it was something like, so Justice Roberts rules on the June Medical case and upholds Hellerstedt as precedent because we've got to stick with precedent. But in the Hellerstedt case, he was one of the dissents in the Hellerstedt case in stating that this was not a constitutional law. He wasn't with the majority. And so I believe it was this case. It was one of the recent rulings.
Yeah, no, that was it.
But so can you just speak to that lunacy for a moment? That can we actually get to a point in our courts where precedent matters more than what you feel as a judge to be constitutional and morally right and wrong?
Yeah.
What's going on?
What's become clear is that the Supreme Court has bought its own lie of judicial supremacy, that an opinion constitutes or equals the Constitution, and so the Constitution shouldn't change every 4 years, depending on who's on the bench. And so I have to uphold the precedent. No, your oath is to uphold the Constitution. And so that's what's happened. All of this goes to the question, really, of judicial supremacy. What is supreme? The Constitution or the opinions of the Supreme Court about the Constitution? What is the nature of the judicial power? So people are going to soon learn. We'll release it, I'm sure, by next week. We did a series of video questions for part of our candidate survey that focused on the question of judicial supremacy in particular contexts. And we did a few other things there. But people might say, well, I want to know if you're for vouchers, or I want to know if you're for contraceptives, or No, what you need to know is, what do they think about the Constitution and fundamental principles?
Yeah.
Because there may not be a voucher bill, let's say, or there may not be a contraceptive mandate that comes up, but there's going to be something, like with how we began this show. Do you understand the separation of powers between the legislative branch and the executive branch and the judicial branch? Do you understand what the Constitution is versus what a court opinion is and what a court judgment is? If you don't understand those things, you do not have a basic grasp of American government, and you're not fit to hold office.
Yeah.
Regardless of what you might do on any particular issue.
Because the root reason why you got elected to office is not to pass laws. It is to secure our rights that are already there in the Constitution. We have just forgotten that.
Yeah.
No one's doing that. No one seemingly is going into office with the understanding that, okay, I'm going here to protect the rights that we have in the Constitution. It seems like people go into office saying, oh, I've got to create new rights. I've got to do new things. No, you don't. You just need to protect what we already have.
Yeah. Yeah, that Adam McLeod said that so well, that the purpose of civil government is to protect the rights we already have. Pre-political rights. That's what the Ninth Amendment is. It is interesting. I'll close on this little note. I read the lawsuit that's been filed against the governor and Mayor Cooper and all that by...
From the bar owners?
From the guys
in
that own
Nashville.
bars.
Yep.
It's a great complaint. And
yeah, it is.
And you know what they did? They cited the Ninth Amendment in there.
Did they really?
They did. I love it. And I can't help but wonder if all of our talk about that helped.
Yeah.
Because, see, they're asserting that
Come
we
on,
have
bar
rights.
owners.
Yeah.
You guys understand the 9th Amendment. We're with you.
Yeah. See, they understand liberty is the freedom to move around, to not be restrained by government, so on and so forth. And that's what the 9th Amendment protects, that kind of liberty, not made-up liberty to go kill my baby. You have the liberty to go to the doctor's
David,
office.
we're going to have to interview those guys on God, Law, and Liberty.
Well, I thought about calling
someone
the lawyer
in Tennessee is suing on the basis of the 9th Amendment. That's incredible.
Yeah, I thought that was fun. So that's a good way maybe to end the day. Yeah.
Well, hey everyone, we're watching out for you. We got some crazy times, crazy stuff going on, and only God knows what we're going to be talking about next week, honestly, because there's going to be 20 things that will be happening between now and the next time we record God, Law, and Liberty. So stay vigilant. Hey, if you haven't, you should go read your Constitution. You really should. You should read our Tennessee Constitution. You should read the U.S. Constitution, because guarantee you we're going to be responsible here for defending our own rights, quite honestly, which frankly aren't we always. And that's why we're here on this show. If you have any questions or concerns, comments, we'd love to hear them. You can always email us at info@factn.org. That's info@factn.org. And until then, we'll see you next time. God bless you.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's factennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.